ready to begin, just go ahead.
Okay. My name is Jennifer Slocum Bailey. I am a District Associate Court Judge in Judicial District 8B, and I am proud to represent the 8th District as its only applicant for the vacancy left by Judge Mullins. I live and preside in Des Moines County, Iowa, which is my hometown. I sat before a substantially similar commission just a few months ago, so I want to offer something a bit different than the biography I offered at the last session. I want to tell you why I am particularly well suited to the Court of Appeals and for this particular vacancy. It may be a little dry as it involves statistics, but in 2020, the Iowa Court of Appeals decided 1,168 cases. So going over 9 full-time judges and senior judges, that equates to approximately 100 cases per judge. The point being, as you already know, it's a voluminous court. And so my first point being that I can handle a large docket and have shown that in the 6 years I have been on the bench in Des Moines County. I handle everything from traffic cases to Class D felonies, handle jury trials, bench trials, motions, pretrials, sentencings, and all the things that we do in the groundwork of Des Moines County and generally Associate Court. I also handled child and native assistance cases, which is by far the most time-consuming part of my docket. And I do so in a way that I feel is effective, but is more than what is statutorily required. So after disposition and before permanency under Code Chapter 232, we're only required to review cases every 6 months. I never review cases longer than 3 months and commonly monthly because it depends upon the needs of the family. And so that's what I have done since I took the bench. I also handle delinquency actions. I presided over the drug court that we had for many years, and then I shifted to a high-risk court. So the purpose of that was to try to divert kids who committed crimes that were serious by having additional judicial oversight to allow them to stay in their homes and not be put in juvenile placements. Also, kids that perhaps may be charged with innocuous crimes on their face, but are clearly in crisis, and I felt needed additional judicial oversight. And so I would set hearings, sometimes weekly, much to their chagrin. They would have to see me and talk to me about their weeks and talk to me about how they were doing and answer to the court. I also handle adoptions and private termination of parental rights actions, 2 things I never did while I was an attorney. And although from the untrained eye, private TPR actions may seem substantially similar, I can assure you it's a totally different code section, different grounds, and the state is not involved. So that was different, and those are voluminous. I also handle, because there are no magistrates in Des Moines County, small claims and forcible entry and detainer actions, which, as you can imagine, are very frequent. And I have not been reversed. I also have never used a law clerk and deal primarily with pro se litigants. So the issues and the legal questions before me have to be decided by me and have to be vetted for what code section may apply and how I'm going to handle legal analysis, because they simply come to me and say, this isn't fair, and then I go from there. I also handle initial appearances, which means for 4 months out of the year, I work on Saturdays and Sundays, and because everyone that's arrested in our state has a right to be seen by a judge within 24 hours of their arrest, I see them over the weekends. I also handle on-call and do warrants 24 hours a day, and that certainly increased with COVID and doing those things. My point is this. I know how to handle a high-volume court, albeit not a court of review, and I have done so with success. I have never had a ruling that's taken longer than 60 days. I have never had to file a 2210 report in that regard. Also, in the retention election that I ran and was retained in 2018, I had the highest rate of retention in Des Moines County. That's the only county that I preside in at 83%. I also had overwhelmingly favorable evaluations in our plebiscite, which gives lawyers an opportunity to rate judges in various parts of their practice. So now I want to talk about statistics a little bit, in looking at 2020 statistics and what it is that a judge that fills Judge Mullins' shoes will have to do. Criminal cases comprised 35% of the cases that the Court of Appeals filed decisions on, and 9% were PCR cases. Judge Allers calls PCR cases criminal cases in civil clothing, so I am going to lump those together at 44%. That's nearly half the docket. And so my educational background, my practice areas make me extremely well suited to a criminal docket. I attended the University of Northern Iowa on a scholarship for the College of Social and Behavioral Sciences, and I was a criminology major. I graduated with a 3.97 grade point average, and yes, that 1A minus still bothers me. But I also worked at the Lynn and Johnson County Attorney's offices when I was in law school, and ultimately became a prosecutor for 7 years at the Des Moines County Attorney's Office. There I handled all kinds of cases from Class A felonies on down, and I had consistently favorable outcomes to the state. And I was a zealous prosecutor. And then I decided to make myself really uncomfortable and try to be a public defender, which wasn't something that was easy for me to do. What I didn't expect is that it's one of the favorite jobs I've ever had, and I was able to use some of my criminology background and really come to life in talking to my clients and being able to understand their backgrounds, their truths, and also to make sure that I held the state to comport with the laws and the Constitution of our state. It also gave me an opportunity to go outside Des Moines County. There's a bubble there that may exist. And so I traveled outside of Des Moines County and outside of our judicial district, handling conflicts for other public defender offices in Class A felonies, going to Scott County, a variety of other counties. And I also got to work in 8A, of which, that sub-district I had not been to. And so to understand those attorneys and judges there. Also, obviously, as far as criminal experience, the experience I've had as a district associate court judge in the last nearly 6 years plays an important part. But I also want to explain that I feel I have some perspective that a lot of judges may not have that are in my role, not just because of my educational background, but also because I don't think that we can view the judicial branch in isolation. I think it really important to remember the people that we sentence, where they're going, and what they need to do once they're out. So in that regard, I've traveled to almost every men and women's penal facility in our state. I have visited many of the juvenile delinquency facilities, although some of them now are defunct. But I have made that my job. As a prosecutor, I sat through Iowa domestic abuse program sessions to understand when we held these individuals accountable for completing that probationary requirement, why it was valuable. And so that and going and understanding not just that they must be done, but what happens when those things are actually working is something I've made my job. So why does criminal experience matters? I think it matters beyond the 44% that we're looking at for the Court of Appeals. It matters because of Judge Mullins, and he's the vacancy that we're filling. And Judge Mullins had 9 years as a trial judge. At that time, he promulgated the Iowa criminal statute summary chart used by myself and every other judge in the state. And what he's contributed to the Court of Appeals in the realm of criminal law is an important consideration. Next, juvenile law comprises 27% of last year's docket for the Iowa Court of Appeals. And for those of you that may not know, juvenile law, child need of assistance cases, private TPRs, as well as juvenile delinquencies, those are exclusively presided over by district associate court judges. So I am the only applicant that has presided over 1/4 of the docket of the person that will fill the shoes of Judge Mullins. I've also acted as a prosecutor, a public defender, a guardian ad litem, and a representative of the state in each of those kind of cases. For 6 years, I've looked into the eyes of children and families, and I've had good results. And in the outcomes that were not good insofar as termination being required under the law, I have not been reversed. And those cases are commonly appealed, and they are commonly reversed. In fact, I was just affirmed by the Iowa Court of Appeals in the interest of NE. It was published October 20th, the day after my application was submitted. So I will just briefly note a few things in that case. It was a somewhat unique case insofar as I had denied the termination petition the first time around on the mother, and the grounds by which I did so, I have never seen a judge ground based upon that, of which was affirmed by the Court of Appeals, but then ultimately the second termination petition I granted. And the Court of Appeals quoted me as follows, of which when the Court of Appeals quotes you as a trial judge, it's the best part of your day. The mother is very good at completing services and checking boxes, but has previously failed at making good parenting decisions when she is in crisis. The court is concerned that it is only when no one is looking that she exercises extreme and dangerous errors in judgment, which will not be shown while the child is removed and the court is looking over her shoulder. So those kind of fact findings, those kind of observations are what the Court of Appeals hung their hat on in that particular case. So to wrap up the statistical portion of the program, civil cases comprise 17% and dissolution 10% of the docket. Again, due to Des Moines County having no magistrates, I hear all small claims, enforceable entry and detainer action. It has the same burdens of proof. We use the same laws. We use the same rules of evidence, but for less money. But I would argue, especially for people in a rural community like Burlington and in the 8th District, $10,000 might as well be $100,000 to the litigants that are in my courtroom, and I can tell you they are no less invested. However, they are substantially unrepresented, and so trying to vet the issues that they come forward with me and writing opinions from scratch without the aid of a law clerk or any other guidance is something I take pride in. Here's some cases that I've decided in the civil law. Employment law issues, whether damages should be awarded for an adjunct professor's termination and claim of detrimental reliance under the promissory estoppel doctrine. Requests for money damages awarded to a plaintiff and who carries the burden to submit chiropractic bills when they are not submitted to the medical insurance in a timely manner. Requests for damages by a regional utility service when they build individuals in a particular city of which the ground was not built on and of which no contract was entered into, and whether or not those landowners would be required to pay those bills. Those are just some of the issues that I have to decide, and I have decided. As far as dissolutions, in my year of private practice at Aspelmeyer Law Firm, I handled dissolutions. And I feel comfortable in that area, especially given my juvenile law experience, talking to families, applying best interest analysis, and dealing with pro se litigants, which increasingly there are during dissolution matters in our state. So I have tried to show I can handle a large volume docket and have experience in virtually every area of the law that the Court of Appeals reviews, but I also believe I'm uniquely situated to take this vacancy. And that's not to say that the role should be filled simply because I'm an 8th District resident. But Burlington and Des Moines County is my home, and we are proud to claim Judges Miller and Mullins as our own as prior 8th District Court judges. And with Judge Mullins' retirement, there is no one from the 8th District on the Iowa Supreme Court or the Iowa Court of Appeals. Our district is largely rural. It is a district that abuts the Mississippi, Illinois, and Missouri. And being from the 8th District, I know a few things. I know that there exists no long-term inpatient substance abuse treatment programs, but for in Ottumwa and 8A. I also know the unique challenges that exist when litigants uproot their lives and their families to attend inpatient treatment and return to a community where there is limited aftercare and support services. I also know that transportation is a problem for our litigants, as public transportation in most areas in our district doesn't exist. And so recently I found reasonable efforts for the department included providing a father a bicycle so he can make it to his appointments and understanding what that means. I also know Louisa County has a large Spanish-speaking and Burmese population, of which I served as a public defender, and what those particular populations, the challenges they were confronted with as criminal defendants. I also know that North and South Lee County are not the same, and to confuse the two means you've never been to either. I have always wanted to be a lawyer since I was a child. My dad worked at Case Corporation, assembling backhoes, and farmed our small family acreage, and my mom was a psychiatric nurse. I didn't know a single lawyer or judge growing up, but I know that to understand the law is to understand the basic rules of our society. And to understand the basic rules of our society is to be able to do justice for all members of that society. For 16 years, I have done justice in the 8th District in every role our court system has to offer. My want to preside on the Iowa Court of Appeals is a natural extension of this pursuit. It is an opportunity to represent the 8th District's proud legal tradition and our unique demographic and affect the just rule of law across our great state. Thank you, and I'd be happy to answer questions.
Thank you. Ms. O'Brien?
Yes.
Thank you. Do you think the district court is adequately set up to handle the large volume of pro se litigants? And then can you apply that to the Court of Appeals setting in how that would be handled?
Well, I mean, I think that, as I pointed out in my personal narrative, obviously dissolutions and even some criminal cases, you see a surge in pro se litigants. And I think there's been a response from the Iowa Supreme Court and, promulgating forms and things that are essentially templates to make it an easy ability for pro se litigants to file claims and to be responsive. In the district associate world, pro se litigants involving criminal and small claims matters are very commonplace, as well as the fact that most of our cases are done in writing and there are no records that are made. So taking that perspective, I certainly believe that, those inherent difficulties in dealing with pro se litigants is important. Being able to talk to someone and meet them where they are is extremely important. It's one of my favorite parts of my job, to be able to make sure that the pro se litigants particularly, understand the decision that I made, even if they don't agree with the ultimate conclusion. They understand the law I relied upon and the facts, and they feel that they were heard, even if they're in disagreement. But yes, it is something that the district court is going to have to adjust to, just as the district associate court has adjusted to it and has made it commonplace. And it's going to be an issue that's raised in the Court of Appeals, I have no doubt. Thank you.
Ms. Pearson?
Good morning, and thank you for being with us.
Thank you.
First of all, my question has two parts.
Okay.
When we spoke, you commented that when you come into a courtroom, individuals know the type of judge that you are.
Mm-hmm.
That's the first part. And the second part is that you feel very fortunate that you had the opportunity to be mentored by some judges, and they gave you some good advice. And
Yes.
would you please share that advice that they gave you with us as well, and how
Sure.
that shapes your work today?
Well, I think it's easy to want to mentor other judges and other attorneys when you yourself have been mentored. As I said and commented to another commissioner, it can never be discounted, the weight that your opinion as a judge holds with the lawyers that appear in your courtroom and with new judges. The critiques, the insights, just from practical experience working on the bench. So I am always assigned the new prosecutor because the county attorney's office, I believe, knows that I will guide them in the same vein public defenders. And I take that as a compliment because I want our bar to be strong. And so it's common after trials, after sentencings, when things are complete, we sit down and we dissect the case. We talk about, if there was an objection that was sustained, they tried to rehabilitate it, they couldn't overcome it. Well, here's the piece that you were missing. And to talk both sides about best practices and the rule of criminal procedure and the rule of law. I think that's my job. And I think that's my job on the Court of Appeals, to strengthen the bar in our state. As far as mentors that I've had some tremendous advice. I think that it was you who I talked to that said the best and most practical advice was simply just take a recess. Just take a 20-minute recess, phone a friend, which I did many times. First taking the bench. I don't know what to look for. I don't know what I'm going to do here. But you can take a breath and you can research and you can find the answer, and that's what you need to do. But I think that the most important thing that I can do for my job is to show kindness and respect and professionalism to the people that appear in front of me, including lawyers and the people in our community. And that's what was modeled to me in our district, and that's what I hope to continue to model and what I think that I aspire to do.
Thank you.
Yeah.
Thank you. We're out of time for questions, so we wish you the best.
Well,
Thank
thank
you
you
for
all
your application.
very much.
Thank you.
Thank you.